New body corporate laws commencing 1st of May 2024. On 21st of March 2024, the Queensland Government issued a proclamation regarding the Body Corporate and Community Management and Other Legislation Act of 2023, or the BCCMOLA Act. Commencing on 1st of May 2024, which is less than 2 weeks away, if you're watching this video at the time of creation, there are 4 new major updates coming that I want to quickly discuss. Special shout out to the REIQ for providing the information for this blog today. Number 1, termination of community title scheme. Where there is less than 100% agreement to terminate a CTS or community title scheme, these new changes introduce a process to facilitate the termination of a scheme, providing specific requirements are met. The basis of the termination has to be for economic reasons. The new process includes preparing a pre-termination report, the body corporate at a general meeting deciding whether there are economic reasons for the termination, passed by a majority resolution, and the body corporate also passing a termination plan resolution, which requires body corporate to prepare a termination plan which contains important information for lot owners. This termination plan must provide for minimum compensation for lot owners, as well as compensation for parties with particular contractual interests in the scheme. After giving lot owners a copy of the termination plan and following a prescribed timeframe, the body corporate can then hold a general meeting to consider a motion for termination resolution, which will only be passed if 75% or more of the owners vote for the motion. If a lot owner disagrees with the motion, there are consumer protection mechanisms to ensure they can dispute this motion. This includes making an application to the court or a specialist adjudicator. This, of course, is a high-level overview. If you want to know more about the specifics, REIQ has released a fact sheet that dives into the specifics of this new legislation. Number 2, second-hand smoke in community title schemes. Body corporates will be permitted to make bylaws that specifically prohibit or restrict the smoking or inhalation of smoking products on the common property of a scheme and on the outdoor area of a lot. An outdoor area of a lot includes a balcony, courtyard, patio, and veranda. These new laws do not impact a lot owner smoking on the inside area of their lot. Smoking products are defined as per the Tobacco and Other Smoking Products Act of 1998 and generally include tobacco products, cigarettes, and vapes. Number 3, keeping or bringing of animals on a lot or common property. Body corporate bylaws cannot prohibit the keeping of an animal on a scheme or restrict the number, size, or type of animals that may be kept. However, there are now prescribed procedural requirements that the body corporate must comply with if a bylaw requires the owner or occupier to obtain body corporate permission to keep an animal. These requirements include that the body corporate must not reasonably withhold an approval to keep an animal. The body corporate must provide a response within a prescribed period as governed by the relevant legislation for the scheme. Any conditions of approval must be reasonable and appropriate, and the body corp must provide its approval and conditions of the approval in writing. The body corporate may refuse to grant an application if keeping of the animal would pose an unacceptable risk on the health and safety of an owner, keeping the animal would break a law, the animal is a regulated dog under the Animal Management Cats and Dogs Act of 2008, keeping the animal would interfere with another lot owner's reasonable use and enjoyment of their land, keeping the animal would unreasonably interfere with native fauna that live on or visit the scheme, or the lot owner does not agree to reasonable conditions proposed by the body corporate for keeping the animal. If pet owners are denied by body corporate, they can lodge a dispute and proceed to adjudication to fight for approval for their furry friends. We have had experience with this, so please reach out if you need help. Towing of vehicles by body corporate. With these new updates, nothing in the BCCM or Body Corporate Community Management Act prevents a body corporate from towing a motor vehicle from common property of a scheme. Keep in mind, everyone, that these new laws will start on the 1st of May 2024. 95% of viewers that watch this channel are not subscribed. If we have provided you with any value over the last year with our videos, please do subscribe and leave a comment or a like. Our goal is to get to 50% subscribe rate. So we're already 5% of the way there, and we can only do this with your help. It allows more people to find our videos that we can educate and help with Queensland property law. Have a great day ahead, everybody. See you next week. Ladies and gentlemen, please keep in mind that all advice is general in nature and does not constitute legal advice. This is authorised by George Souris Empire Legal, Gold Coast, Queensland, Australia.